Welcome everyone to today's webinar. Thank you for joining us. Today I'm delighted to have a panel of experts to talk to you about the private wealth and tax sector. We're specifically aiming today's webinars at our entrepreneurial clients, so those that are running businesses. And we're thinking about the sort of issues that we need to highlight to them and what they should be thinking about during this difficult time. We're obviously broadcasting this during the epicenter of the COVID-19 pandemic, and clients are looking to us for guidance, for reassurance, and for advice on things that they should be specifically focusing on to help them during this time. So I'm delighted today to be joined by Matthew Biles, our Head of Private Wealth, Robert Young, Director of Hanover Financial Management, and Hugh Witty, our Head of Tax, all based in London, working in the Ince group. So the first question today for the panel, lots of our clients and contacts are getting in touch with us, naturally very concerned about contracting the virus and frankly the possibility that they may even die. And one of the issues that is top of mind therefore is whether they should make a will, or if they have a will, should they be revisiting this for any reason? Matthew, can I ask you to start on that topic, please?
Sure. I think fundamentally, yes, having a will in place is, in my view, an absolute necessity. It's a fundamental legal document that is particularly complex to execute, but the reason for that is the import it carries. It will govern your assets after you die, whereas any other kind of informal agreement you think you have in place with business partners or your spouse, etc., they may be on it, they may not, and the reality is the will brings that certainty. In relation to actually implementing a will, there generally, for entrepreneurs specifically, seem to be two levels of concerns. One is that their family's looked after, and the other is that if they have a business partner or partners, that their legacy continues, and that the two don't tread on one another. So one of the things I've often seen is that the entrepreneur is keen for the value of their work and their legacy to pass to the family, obviously, so that their spouse and children can inherit and enjoy that. But they're often keen to allow their business partners to continue as a group, possibly potentially without the inclusion of the spouse, in that they may not have been involved in the day-to-day running, and that they have full confidence and trust in their business partners. Now implementing that is exactly where a will comes in. It allows you to detail, how you want that dealt with. This can be achieved via the use of, gifts or the use for trust, etc. And it just provides that certainty for both your business partner and also your spouse. But of course, you can also think of it the other way. You may be the other business partner, whereby your business partner dies and you are the one who's left potentially dealing with an obstructive spouse or a spouse who's uncontactable due to the funeral and other kind of issues related to grief, etc. And then just beyond that, you can stray into the everyday concerns. If you don't have a will in place, then the chances are you'll have inheritance tax to pay on the death of the first spouse. If there is a will in place, subject to certain caveats, you can almost certainly avoid it. That avoids 40% being levied on, your lifetime's earnings. You preserve wealth, it grows quicker thereafter. There is more in the pot at the second death. And then you can drill down into the minutiae, appointing a guardian. I mean, you almost certainly won't have noted anywhere else who you'd like to be your children's guardian. Your will can cover that. And just a variety of steps really that give, you certainty and your family certainty.
And as you touched upon, if you don't have a will, you really are left in a very detrimental position, I understand.
Yes. So there are a fixed set of rules that the statute applies called the Intestacy Rules, and essentially they're, for want of a better word, Parliament's best guess of what they think most people would like to happen. But the reality is that may well not reflect your circumstances. Family disagreements aren't unheard of. Your will allows you to cater for that. And specifically deal with it, whereas the intestacy rules are just a blanket application that divide your wealth, quite possibly not as you like. Furthermore, on the point of family disagreements, if there is any beneficiary who you do not wish to benefit and you choose to leave them out of your will, it's important that that's made apparent and reasons for that detailed so that it can be protected. I mean, I'm sure we've all heard of, newspaper articles where, claims from, disinherited children have succeeded, even though it's, well, to the wider public's view, grossly unfair and not what the deceased would have wanted. But that is the world we live in, and clients need to take steps, to implement their wishes.
Lovely, thank you, Matthew. Robert, would you like to add to that?
Yes, and certainly Matthew mentioned there issues that can arise in the event of your death or even your incapacity to work that affect the value of your business. And we can come up with some insurance solutions that will help you get around that. The two I'm really thinking of here are either Keyman Insurance or shareholder protection insurance. Keyman Insurance is basically designed, it's written as a life policy or perhaps a critical illness policy. Beneficiary is the business, so they get some money. And in the event that you're not around, someone's going to have to take over your role. That's not going to be able to be done straight away. So it will take some time to find a replacement, and the business is going to need capital to continue during that time. So an insurance policy can do that, which helps the business you spend a long time building up continue and maintain its value. The other issue which he also touched on was the issue between yourself and perhaps your co-shareholders. And this can work all the way around in the sense that you can have co-shareholder agreements and shareholder protection that covers all of you. So we can look at the value that you need for that. And the point about that is, again, this event might happen when your co-shareholders don't have the capital to buy your shares at a value you think is reasonable. You want your family obviously to benefit from all those endeavours. The insurance can provide you with that capital, and that can then give you the means to satisfy everyone, really. Your co-shareholders continue with the business, and your family have assets that they can use to tide them through the difficult times ahead. So that's really where we can help.
Thank you. And I know that some of our viewers will be thinking, are we really going to be able to obtain insurance in these difficult times where insurers are having to sort of do desktop valuations? And obviously now that we're right in the thick of COVID-19, lots are making exceptions. But I understand you have some experience actually managing to get some cover despite this.
Yes, I mean, the amount of cover that you'd be able to get at the current time does tend to depend upon your age and obviously on any pre-existing medical conditions. But even up to age 60, we've managed to get £100,000 worth of cover with no medicals. And you've also got insurers now looking at how to do at least limited medicals in a kind of at-home environment. So they send out kits for you to do some of those tests. Obviously, they can't do the full test. That will still perhaps mean really big sums of sure can't be placed. But there's still a bit of place some funds at least which will get you through some of the problem.
Great, so it's definitely something we should be speaking to people about and exploring their circumstances. Lovely, thank you, Robert. Hugh, is there a tax angle here that you want to mention?
Yes, briefly. I mean, I think Matt dealt very well with the tax issues that come out of drafting a will. Essentially, if you're talking about a businessman who's leaving a substantial amount of his assets to his wife through business property relief and spouse exemption, you should be able to save inheritance tax at the point of death. If something were to go wrong and it wasn't properly drafted, you do get a second shot at it by varying the will if all the beneficiaries can agree. So that's the second way to minimise your tax liabilities. The only other point I wanted to pick up on was the Keyman Insurance, which was being referred to by Robert. And that's to say that when you're paying this out of the business, there's always a question of whether you get tax relief for the insurance premiums paid. And you should do, provided the payments are made to benefit the trade going forward and not to benefit the shareholders. If it's the latter, then tax relief isn't available.
Lovely. Thank you very much, Hugh. Okay, so we've covered the awful scenario that so many people in the UK are having to contemplate at the moment, losing loved ones to this virus. We've got a whole raft of other people that are thinking, hopefully worst case scenario won't happen, but could be likely, if not very likely, that they succumb to this illness at some point. And for entrepreneurs, that means the worst news, that they're actually not able to work in their business for a period of time. So we're seeing an increase in inquiries regarding lasting powers of attorney, I understand. Matthew, can you kick off by telling us briefly what they are, what they do, and why entrepreneurs should be thinking about putting one in place?
Certainly. Well, I mean, I think the slight misnomer about powers of attorney is people always think, one, you will only need them when you are elderly, and two, that the reality is that they're quite complicated. And the ability these days to do them digitally takes away a lot of that uncertainty. One of the other issues is that the LPAs, as they're called, lasting powers of attorney, they're now divided into financial and property and health and welfare. So if you wish, you can essentially appoint different people to do different things. That actually goes one step further in that you can make a business specific power of attorney in relation to your business. You could appoint a business colleague, whereas perhaps you'd want your spouse in charge of the bank accounts, family, home, etc. They're very useful. They don't only apply when people lose mental capacity. So as you touched on, it could simply be that unfortunately people are struck down and, in the example of our Prime Minister, aren't able to come back to work straight away, but yet key decisions need to be made, especially in these hugely uncertain times. And a power of attorney authorizes people to act even if you physically can't make the decisions or logistically can't get to where you need to be. We're all very much aware of this age of kind of data protection and client confidentiality. Reality is, if you don't have a power of attorney, appointing you, that you can't actually access a lot of this information. Banks just simply won't talk to you. Whereas if you put one in place, they are relatively low cost. You can put one in place relatively easily. There is a safeguard required, but solicitors are able to confirm people's mental capacity. So a lot of the people we're speaking to will know their clients, will know that position, and very much in the private wealth team, we can help them with that. And then once the power of attorney is in place, they're authorized and can deal with all those implications very effectively. I think it's certainly worth something considering. I really would recommend people do it. I mean, if the worst were to happen, very much, I mean, it could simply be beyond the effects of COVID-19. If you think of the unfortunate example of Michael Schumacher, it was simply a skiing accident. But if you don't have one in place, there are dramatic consequences. You then have to apply via the Court of Protection, which is essentially a blank slate. You have to make the application and essentially prove why you should be the person, and this applies even to spouses. And so it's a very invasive process and it's very costly. Whereas an LPA you can do now, and it will, serve you well, for the rest of your life if you wish it to.
So you only have to do it once, and it could last forever.
Yes, yeah, there has a facility to appoint an attorney, and then what we term replacement attorneys. So, for instance, if you've got a spouse, but they predeceased you, or perhaps they lost mental capacity, the replacement attorney safeguard would kick in, and it might be, say, your children jointly you've appointed or something like that. So it's not one shot, it builds in kind of generational protection.
Great, thank you very much. Robert, is there an angle that you'd like to speak about there?
In the book, where I would come on here is that, as well as talking about life insurance, obviously we can talk about critical illness insurance and income protection insurance. Some of these may be, again, as we illustrated earlier, not so easy to put in place right now, but income protection policies, can give you an income stream even if you're incapacitated, not able to work, and that's the difference there. You've got an income stream out of that, whereas a critical illness policy will give you a capital sum. So different policies will suit different people in different situations, but at least there's protection that could be obtained.
Okay, thank you very much. Lastly, I'd like to come on to succession planning. We've gone in, because of the pandemic that we're dealing with, I guess we've gone in order of urgency, getting that will sorted out so that worst case scenario, the entrepreneur and their family and their business are protected. We've then talked about lasting powers of attorney to put in place for that period where they're unable to work or to operate at full capacity. What I'd like to touch on now is just general succession planning, something that we always want to talk to clients about, but often it's not top of mind when, especially with entrepreneurs, they're running at 100 miles an hour, running the business every day. But what can we do now in this time when maybe we've got a little bit more time on our hands, or these matters are just more top of mind than they normally would be? What would we be talking to our entrepreneur clients about now in terms of succession planning? Matthew, if I can come back to you.
Certainly. I think it's very much something that we find comes out of the will making process, is that as part of that, there's a kind of a disclosure of assets. We need to know what everyone owns so that we can then advise appropriately. And what that often teases out is that there are lots of novel assets, or perhaps that the people making the wills have reached a level of wealth where they are trying to make gifts, but they're either too frightened to do it for fear of triggering tax consequences, or doing it in a incredibly inefficient way. I mean, I'm aware of going into too much detail, but fundamentally, there are all sorts of IHT reliefs. You can gift out of your income. If you have surplus income each year, you can gift out of that. Inheritance tax free. There's the ability to set up trusts during a lifetime, which can then be topped up during that lifetime, or simply be topped up at the death if there's some kind of tax advantage in doing so. Trusts are also a great protector in case of, shall we say, younger, potentially financially immature beneficiaries, protecting them from, bankruptcy, divorce, things like that. If they inherit absolutely, then, and they do divorce, it's 50% of everything goes across. Whereas if it's in a trust, that's, much more likely to be protected. And then beyond that, there's business assets, as Hugh touched on. There are a spouse inheritance tax exemption, but also a business property relief exemption. Reality is, if the client is minded, you could split that out and essentially, preserve the two IHT exemptions and kind of double your saving. And then beyond that, it trickles down to everything. There are annual gifts that can be made. I think on the succession planning angle for entrepreneurs, I think particularly having a think about shareholders agreements during a lifetime is also an incredibly worthwhile step. We're straying more into kind of the commercial corporate side of things here, but it still does dovetail with financial planning and also succession planning. And even articles sometimes need to be reviewed to ensure that the preemption rights of purchasing a deceased person's shares don't actually deny that deceased person inheritance tax relief under the business property rules. So it's just the kind of a financial checkup that clients, a legal financial checkup that clients may need and may be helped to be guided on, and things like that.
Thank you. Yeah, clearly a lot to think about there, so well worth a consultation. Robert, can you give us your view on some of those points?
So one of the main things that I get involved in when we're looking at IHT issues is when the gifts are made and you've got the pass-through exempt transfer rules. That means they will get exempt for IHT, but not until after 7 years. You survived 7 years. So one can put in insurance to mitigate against any IHT that might arise in that 7-year period. And because it's a term insurance policy, it can be relatively cheap, perhaps cheaper than you might expect. So that's one good thing. And we can also design, one of the things I find is that people don't always just give one set of gifts, they do it at all various random times. So you can build a model of what the actual tax liability is. So we can kind of develop an insurance framework around that. If there's going to be an ultimate potential IHT at the end of their life, one can look at whole of life policies. Naturally, they tend to be more expensive because they are going to pay out, just don't know when. So that's a difference there. So so there are various insurance solutions that will actually help mitigate any potential IHT that would be paid.
Fantastic, thank you.
One other thing, there are some investments that you can use that perhaps can actually help relieve IHT. So if you've got excess money, if you go into some AIM portfolios and things like that, that after 2 years, that can get you some IHT relief as well. So some other solutions on insurance, on the investment side as well.
Great, thank you very much, Robert. Hugh, can you talk us through some of the tax angles on succession planning?
Yeah, I mean, a lot of the tax angles have been sort of touched upon already. I think what I want to say is look at the fact that as we're in the middle of the COVID-19 crisis, asset values are substantially reduced. And on that does give us planning opportunities. So for example, if you've got the owner of a business, it's qualifying for business property relief, so the shares can be gifted away to relatives other than the spouse without incurring liability to inheritance tax. It may be sensible to try and share the ownership of the company now, time when there's low capital gains tax, no inheritance tax, with a view to the business being sold, say, in 2 years' time. If you do this, you'll say you'll defer, you'll avoid any immediate tax charges, but also you'll be able to spread the gains amongst members of the family so that actually you can realize, so actually you can utilize everyone's ability to claim entrepreneurs relief on the sales of those shares. And that can produce quite a big tax saving, especially as the lifetime limit for entrepreneurs relief has dropped from £10 million to £1 million in the budget this year. The second area I wanted to comment on briefly was for non-residents who own UK property. Again, it's only over recent years that UK properties have fallen in the scope of UK capital gains tax. Non-residential has fallen from 2019 and residential from earlier on, 2015 or even 2013. But the point is, if property values are depressed at the moment, it should be possible to transfer the properties around your family without giving rise to the capital gain. And if you're putting them down a generation, and you survive 7 years, you'll then have saved the inheritance tax on these properties as well. So in the context of succession planning, there is a lot you can do, but it is something you need to think about in advance. It can't be left to the last minute.
Fantastic, thank you, Hugh, and thank you to our panel for covering those 3 topics today: wills, lasting powers of attorney and succession planning. We do appreciate that these are topics that none of us really like to contemplate, but as you've heard today, it's so very important that we do so. If you'd like a confidential discussion with anyone on the panel, please don't hesitate to contact us. We're always happy to have a no obligation call to see if we can help you. Otherwise, if you found the webinar useful, please do give us a like on social and share us with your network, and do let us have any comments or feedback. Please take care and stay safe, and we look forward to seeing you again soon.